Good morning, everybody. Welcome, welcome. My name is Dana Sparks, and I am the director of the Real Estate Academy of America, which is the school that is offering this course for CE credit. I am also the qualifying broker of Maximum One Greater Atlanta Realtors, and Maximum One companies are sponsoring this CE class. So the reason I tell you that I am also the broker of a real estate company is that this is a contracts class, and I see a lot of contracts. I don't see every contract. We have a completely separate compliance broker, but I see the ones that have issues and questions and very interesting things. Based on that, I also have a YouTube channel, Real Estate Made Crystal Clear. And my target audience for that is every agent in the state of Georgia. And I elaborate on these interesting issues that I come across in a variety of contracts, as well as questions from teaching. So I invite everybody to check that out. So we are going to get started, and I hope I will answer your questions with the notice to students and as we go on. So I got one person that says they cannot hear me. Can everybody else hear me?
Yes.
Okay. Yes. All right. So I'm sorry, Christy, you need to check your computer. So, all right. Well, let me just share my screen, and I believe all of my prefaced remarks are going to be covered actually on screen. So here we go. Welcome, everybody. We have a big class and a lot to cover. So let's dive in and welcome. I'm so excited you guys are here. So I'm going to share my screen. And if you see me looking to the side, I've got another computer so I can see what you guys are seeing, as well as I have the chat right here in front of me. So, all right. This is today's course, the 2023 GAR Contract Dissection. It is Georgia Real Estate Commission course number 75553. I am the instructor, as I mentioned. It is sponsored by Maximum One Realty Companies at keepmorecommission.com. There are handouts for this class, but you do not need them. Everything in the handout is going to be covered in the class. However, I do strongly suggest that after class, you go, or during the break, whenever you choose, that you go and you do download the handouts, because there is a ton of information in this class. I am not going to cover it all in depth, or we would be here for way more than 3 hours. But a lot of my notes, you'll see as I go through the handouts, a lot of my notes are there. They are underlined. And I like to give handouts as a reference for my students to have throughout the course of their career or the year working. Again, CE is through the Real Estate Academy of America. And for the notice to students, again, the school expires or has to be renewed December 31st, 2026. This is a virtual remote broadcast of an approved in-class class course. For any and all virtual CE classes, you may only take one CE class at a time virtually. Just think, if they were in person, you can only be in one place at a time. So if it is discovered that you are taking more than one virtual classes with overlapping times or at the same time, you will not get credit for either class. Additionally, for the attendance policy, so this is going to answer a lot of your questions. For our school, the Real Estate Academy of America, all students must be on time and present for all remote virtual broadcast instruction hours in order to receive credit. The way we do that is through the chat function. So you need to type in your name, your Georgia real estate license. For whatever reason, we get a lot of people learning about our classes outside of Georgia. And this class is currently approved for your Georgia real estate license, regardless of where in the state you are. So I need you to type in your name, your Georgia real estate license number, your email address, and your phone number. We do that in case we have recording issues. And you will need to do that 3 times at the beginning of class, when we come back from the break, and then before you leave. That's how we gauge attendance. Additionally, I will ask questions throughout the course of teaching this class. Please go ahead and type in your answers in the chat, even if I have given the answer based on time, just so that we can demonstrate that you are here and paying attention to the class, and not you didn't just turn on your computer and walk away. If you have any questions, please also type them in the chat, and I will get to them at a logical point in the presentation. No recruiting, and if so, let myself know. I'm the director of the school. Heidi Kelly is the coordinator of the school, or you can let GREC know. So before we get started, I just want to tell you all, there is a ton of information. And let me stop the PowerPoint for a minute and let me show you what is available in the handouts. As I mentioned, I am not going to cover everything that I have underlined in the handouts. It is just way, way, way too much information. But I do want you to have all of that information should you need it. So available in the handouts, and I'll go over that a couple more times, are this PDF of all of my slides. And so you will see all of my all of the points that I'm going to cover, including just everything. There are 77 pages that cover all of my slides. Additionally, in the handouts, you will get, I just printed out for you the GAR table of contents. And then here's what I am talking about. Let me make this just a little bit bigger so you can see it. And now it's time for me to put on my glasses. So you will have all of my handouts. And as you can see, they've got all of my underlines and all of my notes. And this is the purchase and sale agreement. This is the assignment. This is a new amendment to assign a contract. This is the counter offer. This is the conventional loan contingency exhibit. And again, all of the handouts have all of my notes and underlines and all the pertinent things. I've got FHA, VA, the new no financing exhibit, community association disclosure, all of the forms that we are going to discuss today. Ah, shoot, I just got rid of something. Are available in the handouts. I think it was 15 that I got rid of. Yeah. All right. So I just wanted to show you what is there, but all of these points I will cover in the slideshow. And again, I'm going to put one more time in the chat. You don't need them for the actual class, but you will want to get them after class or at the break. And that's where you can get them. And I will walk everybody through that when we get back from break or at the end of class. All right. We are going to dive in, everybody. As I mentioned, there is a lot of information. I am not going to cover everything that I have underlined, or we would be here for years. No, maybe not years, but a long time. So generally speaking, GAR, which is the Georgia Association of Realtors, they make changes to the contract based on what's going on in the market, as well as information that they receive back from agents throughout the year on issues or questions or concerns that agents have throughout their practice. And you guys will see when we get to one of the new forms, there's a question that I have, and I'm hoping that the GAR Forms Committee will answer me. So GAR revises their forms at the beginning of every year, and then they do a mid-year revision. Their mid-year revision a lot of times is to correct typographical errors or context errors or numbering or grammar, and every now and then they throw in some pretty substantial changes. Universal changes apply across forms, and they are available for licensed agents. If you are a realtor, then you pay for the GAR licensing agreement for the year in your dues, so there's no additional cost. If you're not a realtor, you may use the GAR contracts. You just pay GAR directly for the forms. May not be given to the public. GAR's intent in their forms is to keep transactions together, and their changes are made for consistency. If you are a realtor, there is a legal helpline that you may use when you go to GAR's website, which is garealtor.com. You must be a realtor because you need to put in your NRDS number, which you get by being a member of a local board of realtors. Generally speaking, in any contract that you write here in the state of Georgia for real property, a legal description is required. A general street address, especially in metro areas, is not sufficient per license law because, it's not sufficient as a legal description is required per license law, but an address isn't necessarily sufficient. We all have experience with roads that are very similar. There's Peachtree Road, Peachtree Court, Peachtree Avenue, Peachtree Lane, Peachtree Circuit. And so it's very easy to, the reason for a legal description above an address is to make sure that the deed that is being conveyed is the property that the buyer and the seller intend, regardless if there's something similar with an address. Also, per license law, parties must get a copy of everything they sign. Please make sure your closing attorneys and your brokers also get copies of all exhibits and amendments so that there are no delays in closings, that the lenders and the closing attorneys prepare everything in one way and then the parties amended something and they never got a copy of it. Don't leave any blanks. If there is a blank, if it's not an or situation, you'll put in NA for not applicable or $0. If it is a blank preceded by a dollar sign, you're going to put in numbers. If it's just a blank, you'll put in words. On the counter offer, and you'll see when we get to this, you're going to put in NC for no change. And if it asks for a date or anything else, you do not want to put in to be determined. That does not reflect an actual meeting of the minds, which is required for enforceability. Just a couple more general points. If you are an agent in the state of Georgia and there is a real estate contract for real property and it is subject to financing, per license law, you must complete all the financing terms. You may not leave them blank or to be determined. As an agent, do not hold earnest money per license law. You must get to the broker as soon after receipt as practically possible. And for convenience sake, you'll definitely want to put your brokerage address on the signature page of a contract. There's no GREC license laws regarding what address that may be if you have branch offices. So it could either be the corporate address or the branch office. But for whatever reason, if you do not attend closing or the closing attorney needs to mail something to you, they need to have the proper address. Also, per license law, you need to complete your license number and your firm's license number on every contract. You guys, for the GAR contracts, there is a fill in the blank. Just as a point of practice, if you are an agent participating with a buyer or seller in a contract, and let's say it's a new construction contract, a HUD contract, Fannie Mae, Freddie Mac, attorney written contract, if there's not a fill in the blank for your license number or your firm license number, you need to add that in there. Just because it's not on the contract, you are still responsible to license law to provide that information in addition to the agency representation if you represent your public person as a client. All agents, I don't care who the holder of the earnest money is, and I don't care if you were on the buy side or the listing side. It is your responsibility to follow up with the earnest money. you need to contact the holder. Did you get it? Did you deposit it? Did you get it? Did you deposit it? The earnest money in a real estate transaction for sale, for purchase and sale, the earnest money, once it is tendered, is potentially up for grabs and would be liquid damages should one of the parties default. So everybody has an interest, buyers and sellers have an interest in those funds. So even if you're on the listing side, you need to follow up and find out if the holder received it and made that deposit. Additionally, all buyer and seller signatures are required, and contact information for customers. We'll get to that when we get to the brokerage section. Limit your special stipulations. There is a full library of special stips from the Georgia Association of Realtors. Also, you'll want to check with your brokers and any closing attorneys with whom you work. And also, in addition to this class, there is a whole library of other special stips and forms. Other classes that we teach here through the Real Estate Academy of America, formerly called the Georgia Real Estate Academy, we teach the 2023 GAR contract changes, which we taught December and January and most of February. Additionally, we teach the 2023 contracts review. That's a really fun class. That one's coming up, which is a direct head-to-head comparison of the GAR contracts and the RE forms contracts, which some refer to as the FMLS forms. We teach a full 3-hour class on the RE forms. Then we teach a whole separate class for the GAR contracts and the RE forms contracts on everything else, the brokerage agreements, other exhibits, a lot of the amendments and special stipulations. Because we teach that as a separate class and there is enough to cover in this class with the purchase and sale agreement and the financing, I touch in this class on a couple of the exhibits, but not all of the exhibits that you might end up using in a purchase and sale agreement. And if you are relatively new or jumping back into the field after an extended absence, we teach a more basic class, Contracts Offer and Acceptance, which is basically a 101 Contracts 101 class. All right. There is a reference where you can find our other classes. And again, here is where you can find the handouts for any of the classes that we teach, or not any, but most. We are working on a website to make the handouts and the class a little bit more readily accessible and available to find. And that will be www.realestateacademyofamerica.com. That is in the works, but we are trying to make it easier for everyone to get access to our information. We just have such a strong belief in training and education for all agents in Georgia that we readily share a lot of our information. All right, here we go, everybody. Deep dive. The forms that I am going to cover in this class are the purchase and sale agreement, the counter offer, the financing contingency exhibits. I'm going to touch on the community association disclosure. Closing attorney is holder of the earnest money. Backup exhibit, addendum to the backup exhibit, which is a new form for 2023. The unilateral notice to extend the closing date, TNR, how to reinstate a contract if it has been terminated and the parties want to go back under contract. Then at the end, I have some notes about earnest money that will absolutely help you and protect you in your practice of real estate. And I encourage you to use and look at any and every consumer brochure that the Georgia Association of Realtors does provide. Again, if you have any questions or need anything, please jot down my email. I've got 2 emails. One is a broker, Dana@MaximumOneRealty.com, or this one related to the school, Dana@RealestateAcademyOfAmerica.com. All right, here we go. In the purchase and sale agreement, paragraph A, which is the front page, is where all the fill in the blanks are. And you are going to want to fill in the blanks on page 1 However, the contract in and of itself does reference at the bottom 9 total pages to the purchase and sale. So whenever you are sending or whenever you are receiving a contract, you definitely want to send and make sure you receive the entire document. Because it references pages 1 of 9 and various exhibits and amendments will have more than one page. You want to make sure that you are sending and receiving the entire package, not just the page where the fill in the blanks are, not just the page where your public people have signed, not just the page that has been changed, but the entire package. Again, as I mentioned, the legal description is required in addition to the address. And there I have some resources where you can easily find a legal description. One of the most important ones I left off of this slide is the actual warranty deed that the seller will have when they purchase the property. On the closing date, you will want to be specific, not put on or before. GAR used to have that in their contract several years ago where it said closing to be, I'm going to do this, you guys. I'm going to show you the PowerPoint, and then I am going to flip to the actual purchase and sale agreement also, so you can get a little bit of context. I hope I don't make anybody dizzy, but I believe it's a little bit easier to see, to get a little bit of context while we're looking at the slide. So again, this is where the legal description goes. Purchase price, closing costs, the date. This is where you're going to put in closing date shall be, and you're going to enter in a specific date. You are not going to put on or before May 31st, because that does not demonstrate a meeting of the minds, and that is required for enforceability for real property. For a contract for real property, you can always change it via amendment, but do not put on or before. And then under the section where it talks about earnest money, you are going to fill in either a brokerage or the closing attorney. There are a lot of buyers and sellers that prefer, for whatever reason, to have a closing attorney as the holder. And I will tell you, there are a lot of issues with the closing attorney as the holder. I think a lot of the public think that the closing attorney is a quote unquote neutral party. But let me ask you, think for yourself, are there closing attorneys that you as a real estate agent practicing real estate in Georgia have a relationship with more than others? Additionally, it could be that a closing attorney, one of the public people in your purchase and sale agreement, has an ongoing relationship with the closing attorney. So I totally understand the initial thought that the closing attorney is a neutral third party should there be an issue with the earnest money, but you'll see when we get to that section that it's not quite what the public thinks that is, and nothing's an issue until it's an issue. And there are a lot of closing attorneys that aren't quite as well versed in the contracts as some of your brokers are. And if there is an issue regarding who gets the earnest money in a dispute, you will want the holder to be very well versed on the contracts in order to disperse those funds as they need to based on what the parties had agreed to. If, however, the closing attorney is named as the holder, then there are certain forms that need to be need to go with the contract. One of them has to be an exhibit to the contract, and the other one has to be an agreement by the attorney, signed by the attorney after the binding contract. I'll cover those a little more in depth when we get to that part. Earnest money. You need to check on with the holder on their policies regarding earnest money. The form of the earnest money, if they hold personal checks, how long on that, and amounts accepted per form. For example, some not only closing attorneys, but brokers will not accept a personal check if the earnest money is over $5,000. And if it's over $10,000, many will require a wire. Additionally, if it is a wire, a lot of times the parties will have to negotiate a longer time frame for the buyer to send that to the holder. We're going to cover these two forms a little bit later on. Am I going to cover them now? Yeah, I think I cover this a little bit later on. And time frame. Okay, so let me go back here for a little bit. I'm getting a little bit off. So this is where you put in who the holder of the earnest money is. And as a reminder, GAR has in here, if it is a closing attorney, one form has to be attached to the exhibit, and then the other form must be signed by the closing attorney after your binding. And again, I'm going to cover those in just a minute. Earnest money, here's the form of the earnest money and the amount of the earnest money. And you check the box if you are already in possession, you as the agent are in possession of the earnest money, or the holder is in possession of the earnest money at the time the buyer signs the offer. Or if the buyer is going to send the earnest money to the holder within so many days of the binding agreement date. So that's where those fill in the blanks are. And I've got these earnest money points of practice written here for you to look over, as well as for at the end. I didn't realize I had it twice, but that's okay. Handling of earnest money is a huge issue. So the fact that I have all this information twice now and at the end, I'm not going to apologize for that. Now, again, these couple of slides have to do with just points of practice for you as an agent. And if you are working with a buyer who is responsible for getting the earnest money to the holder without you, the agent, in other words, they're going to mail it in or drop it off or something like that, make sure that they include in whatever transmission, however they get that earnest money to the holder, the property address and the agent's name. Again, typically earnest money over $10,000, regardless of the holder, is required to be a wire. If not, there is, based on the Homeland Security Act, there is an IRS form that the holder is required to fill out. And we do need personal information from the holder. If we have a wire, we don't need that. All right. Again, I have covered this. This will be in your notes. And let's go on with the contract. All right. Inspection and due diligence. This is the section. Again, I'm just on the fill in the blanks page. I'm going to do a lot more explanation when we get to section paragraph B in the purchase and sale agreement, where it goes on and on and on about everything around that surrounds the fill in the blanks. But on paragraph A, on the first page of the GAR purchase and sale agreement, where you are filling in the blanks, where the buyer and the seller are negotiating timeframes and amounts, under the inspection and due diligence period, there is a fill in the blank for the number of days from the binding agreement date that the seller gives the buyer the option to terminate for any or no reason. Y'all, even in an extremely competitive market, I highly encourage you to never put 0 days binding agreement date, because even if a buyer has not sent in earnest money to the holder and you put in 0 days and the buyer terminates the next day, that buyer is in default and may legally be pursued not only for the earnest money, but also for commission. So even in a highly competitive market, please put in at least 1 day to give the buyer time to sleep on it. Because a lot of times a buyer will think, well, I never put in earnest money. It's not at risk if I have 0 days to make my offer more competitive and I just terminate. No, they are still legally responsible for that money. And a lot of our public get this confused. A due diligence period is only a buyer's right to terminate. A seller has no termination rights during a due diligence period. If a seller terminates during this period, the seller will be in default. All right. There is this section here where it says sellers shall pay additional option money. It's in addition to this $10 that never changes hands. We only see this in a highly, highly competitive market. In 2021 and the first part of 2022, we saw a lot of additional option money changing hands directly between a buyer and a seller because it is non-refundable to make a buyer's offer more competitive. It is completely money at risk. It is only refundable to a buyer if the seller defaults. And I do not see this in a more normalized market, which is what we are in now. This is February of 2023 while we are teaching this class. But I just wanted to address that this usually in a more normalized market like we're seeing now, we see 0 there. This is not earnest money. All right. During a buyer's due diligence period, there are a lot of issues that a buyer will investigate to help them make their decision if they're going to terminate or go through with the contract. It is, let me go back to this. Actually, let me show you this. In the due diligence period, actually, I'm going to get to it when I get to the next section. But basically, as I mentioned, this creates an option. It creates like a mini option contract between the buyer and the seller within the broader context of everything they have negotiated in the purchase and sale. Because the seller, again, is giving the buyer the option to terminate and not risk their earnest money if they send notice of termination before this time frame. So none of the rest of the purchase and sale kicks in until we get past this. So because it's an option for a buyer to terminate, there's a lot of things a buyer's going to do to help them make their decision. Am I going to terminate or am I going to go through with it? Now, they can have inspections. They can check out zoning. They can check out the school district. They can make sure that they can have a survey of the property. They can check with the lender, make sure there's going to be no issues with their loan. They can make sure they like the property. They can make sure that where it is in driving distance to where they go. They can check the roof. They can check if it's flood insurance. There's all sorts of things that a buyer will want to check out before making their decision to go through and be legally obligated to the rest of the contract. Now, a buyer may ask a seller, the buyer might say, you know what, I had the house inspected and there are some issues that come up. Seller, will you address these issues? The seller can say, sure, I'll be happy to do that. The seller can say, nope, not doing it. Or the seller can say, well, I'll do this and this, but not that. So even if a seller is selling a property as is, a buyer may still have inspections and may still ask the seller to address some concerns. So you listing agents working with sellers, if they're marketing a property as is and a buyer asks for something, don't have them have a cow. They're just asking. The seller is not obligated to do anything. As is just initially communicates that the seller has no intention of doing any repairs or replacements. And I'll get to a seller's disclosures in just a minute. And this is everything that I just said, all written out for you. All right, moving along in the brokerage section, there is a place where you complete which brokerage firm is working with the buyer and which brokerage firm is working with the seller. And if the relationship between the broker and the public person is that of client, customer, dual agent, or designated agent. Now, if it is a designated agency situation, that is the only time that you fill in the name of the agent working with the buyer. A lot of new licensees or people jumping back in it, if you've got one brokerage firm working with the buyer and one brokerage firm working with the seller, they'll still fill in the names of the agents. We don't need that. We get that on the signature page. This is only if it is a designated agency situation. Again, per license law, if your broker is working with the public person as a client, that is required to be disclosed on a contract. And if you are working with the public in a dual agency or designated agency situation, you need to check with your broker's policy. All right, I'm not going to go over this in the class, but I just have this handy slide as a reminder, as a review of the types of agency: single agency, dual, designated, and having both sides, but not necessarily being dual agency. Then the fill in the blank at the bottom is for a material relationship, which is the relationship between the buyer or the seller and the agent or the broker. Regardless, you would disclose a material relationship, regardless if, excuse me, if you're working with your public as a client or customer. And those are just some samples of material relationships that you would disclose. You don't have to go on and on. You can just put buyer is related to buyer's agent, or buyer is past client of broker. Now, let's get into the good, juicy stuff. Paragraph B, the further explanations. So all of that was just sort of the fill in the blanks on paragraph A, key terms and conditions. Now we're going to go to the next page, page 2, and this begins paragraph B, further explanations. I encourage you guys not to skip all of this stuff when you are working with your public, because this is where, this is all the promises and obligations and consequences of their actions spelled out once they sign the purchase and sale agreement. As a matter of fact, as a point of practice, whenever you are first working with a buyer or a seller, I highly encourage you to pull out a blank purchase and sale agreement and see where this one says, it's hard to see it, but it says for training purposes only. I suggest you write sample or something like that across this. You don't want to, and you want to put a line through it. You do not want to give your public a GAR contract for them to have and use without you. But as a point of practice, you do want to print this out and give it to your buyers and your sellers before they ever go under contract, and give them the opportunity to look at all of this and read all of this, so that you may answer their questions before they actually have to make a decision when there's money on the line and consequences on the line and legalities on the line. So now, for the purposes of this class, I'm going to start going a little bit more in depth on some of these issues. Again, I'm not going to go in depth on everything I have underlined, or we will be here for a long time. So I just wanted to show you in context where we are on the actual form itself. All right, oh, there we go. So there's my point of practice for you guys, to send your party a blank purchase and sale agreement. Again, not blank for them to have and use. You're going to write sample on it. All right. So what is it when a buyer and a seller sign a purchase and sale agreement that they're actually conveying? Well, they're actually conveying title to the property. And this is where it describes that. The seller is warranting that at the time of closing, they're conveying good and marketable title via limited warranty deed. And the buyer is assuming any leases. And if they are assuming leases, they're going to include or reference a copy of the lease. And I suggest you negotiate a copy, transfer of the security deposit. And you must notify the tenant. Now, I'm just going to stay here for a second because there's a lot of times when a buyer is buying a property and they don't want it as an investment property. They want that tenant out of there. But when they go under contract with the seller has been using that property as an investment property, as a rental, and there's a tenant in there. Well, guess what, buyers? If there's a tenant in there, you are assuming responsibilities in the lease. So if for whatever reason that seller does not vacate that property when it's time for you to close, guess what? You are still obligated to close on that property. And then it becomes the buyer's responsibility to evict the tenant if they're not on a month-to-month lease, follow the terms of the Georgia landlord-tenant laws for terms of notice and so forth and so on. So you buyer's agents, if again, this contract states that once a buyer goes under contract for that property, if there's a lease, the buyer is buying it subject to the lease, hoping a tenant might vacate. But if not, that's not termination rights for the buyer. And then the buyer has the right to examine the title. Now, in practice, we know it is not the buyer that is actually doing the title search, but the closing attorney. But here's the issue. The issue is the way we practice real estate here in Georgia. If the closing attorney sends an email to the buyer's agent that says, hey, there's an issue with the title, there's a cloud on title, there's something going on with the title, you need to follow what the contract, you guys, the easiest way to think of the contract is it is a set of instructions. It is a set of instructions on how to get from offer to closing. It's instructions for the brokers. It's instructions for the buyer. It's instructions for the seller. It is instructions for the closing attorney, and it is instructions for the lender. So you need to follow the instructions. If there's an issue with the title, then the buyer is required to send the seller a written statement of objections at or prior to closing. The closing attorney is not a party to the contract. It is not the closing attorney's responsibility to notify the buyer and the seller of a title issue. If you do get communication from the closing attorney, that does not fulfill the terms of the contract. This says the buyer must send the seller a written statement. So I just have as a reminder here for you to use this GAR form F816, which is notice, in order for you as the buyer's agent to fulfill the terms of the contract in order to protect earnest money, because under here I have termination rights if it is not resolved, but you need to protect your buyer's earnest money. Now going on, what is getting transferred? The title, as long as it is, quote, good and marketable title, and that is defined in the contract, meaning title insurance where the premium that the buyer pays is not an elevated premium. It is regular rates that title insurance company would charge. Now, one of the things I just want to address when you get to the section where the seller is making, buyer and seller negotiate if the seller is going to make any sort of financial contribution to the buyer's closing costs. In previous years, well, even here, it does say any unspent, that the lender can use the seller's monetary contribution for the buyer's costs related to closing the loan. And And it does still say here, I don't have it underlined because the effect of this has changed a little bit, but it says, in event any unused portion of the seller's monetary contribution shall remain property of the seller. However, GAR has also added this section in response to this hyper-competitive market we've been in the past couple of years, that any seller's contribution to a buyer's closing costs may also be used towards any commission obligations of the buyer. So if the seller or the listing broker was not paying any of the buyer's broker commission and the buyer was having to pay their own broker's commission, if the seller was contributing to the buyer's closing costs, the buyer could use them to pay their broker commission. That was added in the end of 2022 or the beginning of 2023. So you listing agents, when you are preparing a seller net sheet, whatever dollar amount the seller has agreed to pay towards the buyer's closing costs, don't tell them they're going to get any of that back. Just for all intents and purposes, subtract that entire contribution from their net. Additionally, this is what the seller pays, their side of attorney's fees. If there's any cost to clear up any clouds on title, if the closing attorney has to mail away information, there's costs associated with that, and to pay off any of their proceeds. And then a buyer at closing has to pay transfer tax, costs for the title search and go through the tax records, any costs of the attorney to prepare the deeds, and all other costs related to the closing or required to close, including any other title fees and post-closing fees. Now, when you get to closing, property taxes have to be paid. And at closing, the closing attorney is going to collect the seller's portion of the property taxes, county and city if required, and the buyer's portion. If you are closing prior to basically August in Metro Georgia, then the closing attorney, the tax bills for the majority of our counties in Metro Georgia have not gone out yet. So the closing attorney has to guess or estimate what those property taxes are going to be. They use last year's tax bill as an estimate. Once the real tax bill comes out, it is up to the buyer and the seller to settle up between themselves. If you're closing after the property tax bill has come out for the year, which for most metro counties here in Georgia is August, then the closing attorney will have the tax bill, hopefully if the counties are on top of it, and will have a more accurate assessment of the property taxes that they're going to collect. Now, guess what? The state and the counties are going to get their money. So when you are calculating, estimating what percentage, what portion, what dollar amount buyers and sellers are going to owe for taxes at closing, day of closing belongs to both buyer and seller for tax purposes. So the government gets a little bit extra on that day. Now, when we talk about closing date and possession, there is a right in the GAR contract. You guys, this is only a GAR contract provision. This is not law. And I get a lot of agents that their buyers and sellers are binding on, let's say, a new construction contract, Fannie Mae, Freddie Mac contract, attorney written contract, RE forms, and there's a delay, and one of the agents says, well, we'll just use the 8-day unilateral extension. It's not Georgia law. It's just in the GAR contracts. And so the parties may extend the contract unilaterally for 8 days, but it's very, very, very specific. It must be for one of these specific reasons to unilaterally delay. Now, a buyer and a seller may extend the closing date by an amendment as many times as they want to. But if they're going to use the 8-day extension must be signed and sent before the 11:59 p.m. on the day of closing. But even if you send it earlier, let's say we're scheduled, what's today? Today is, let me give you an example. Today is February 28th. Let's say we are scheduled to close on March 31st. And for whatever reason, we need to use the 8-day unilateral extension. We've gotten a note from the closing attorney. There's a cloud on title. The closing attorney needs a few more days to clear up that cloud on title. Not going to be able to close on March 31st. And we get that information, let's say on Monday, March 20th. You can go ahead and use the 8-day unilateral extension on March 20th. But the date that gets extended, it's not 8 days from the date the notice is given. It's 8 days from the closing date. So it would be 8 days from March 31st. Never, if you go binding on a GAR contract, never schedule a closing on a Friday. Why? Well, again, these are the reasons that a buyer and seller may use the 8-day unilateral. Title objections, as long as it can't be satisfied with money. So if there's just a lien on the seller's title and the seller is trying to negotiate that lien, that's not a reason to use the 8-day unilateral. Or the lender or attorney can't complete their responsibilities as long as the delay is not caused by the buyer. It can only be used one time per contract by either party. So when is 8 days not really 8 days? Only when the original or amended closing date is on a Friday. This is only in the GAR contract because that's where this is. So in the GAR contract, in the purchase and sale agreement, paragraph C4F, and actually I think that letter has changed, it does say extension of deadlines. No time deadline under this agreement shall be extended by virtue of it falling on a Saturday, Sunday, or federal holiday, except for the date of closing. So if you're, let's say you have a financing contingency that falls on a Friday, Saturday, or federal holiday, well, that will still fall on that weekday. I just want to show you this for an example. Let's see if it'll, I don't want to download it. If the only thing that gets changed automatically is let's see if it'll show this one, is the closing date. So, okay, I'm not buying this. I just want to show you. It's an 8-day unilateral extension. If our closing date was scheduled for Friday, March 10th, and again, this only happens when your original or amended closing date falls on a Friday, and one of the parties ends up using the 8-day unilateral extension. Well, what day of the week is 8 days from a Friday? Well, we've got 1, 2, 3, 4, 5, 6, 7, 8. That's a Saturday. Can't close on a Saturday, next day. Sunday, can't close on a Sunday. So the contract, the party, buyer and seller, are automatically still in contract until the next business day, which is Monday the 20th. If that's a federal holiday, it automatically gets moved to the 21st. So that 8 days has now become either 10 or 11 days. It only happens when you close on a Friday. If we close on a Thursday, 8 days from Thursday would be this Friday. So again, that is the reason I'm telling you that is because I look at the contract instructions, and the contract instructions in GAR say that nothing gets extended if it falls on a weekend or federal holiday except for the closing date. So you've got to be very, very cautious when you go binding under the GAR contract. Do not schedule your closing on a Friday because you're moving it to 10 or 11 days. All right, moving along. Basically, I just want to cover there's a lot of confusion with our public on the closing law firm. Okay, I'm going to ask you guys a quiz question. Keep you guys awake. If there is a loan, then the closing attorney represents the mortgage lender. If there is no loan, whom does the closing attorney represent in the GAR contract? Type it in the chat. No loan. Who does the closing attorney represent? Seller, buyer, buyer, buyer. All right, no one. Okay, a lot of interesting answers. So what do? Well, let's look at the instructions and let's see what the instructions say. So under the section of closing a law firm, it says the buyer shall have the right to select the closing attorney. The closing attorney must be acceptable to the mortgage lender. Now, here's where we talk about if there's no financing. In transactions where the buyer does not obtain mortgage financing, the closing attorney shall represent the buyer. But what does that mean? Well, they're representing, the rest of this is spelled out here. They are representing the buyer only for preparing the closing documents, clearing title, conducting the closing, dispersing the funds, recording the deeds, and issuing owner's title policy. However, what your buyers think, what your public thinks, is that means they've got legal representation if there's a dispute or if there's a title issue. That is not the case. I don't know of any attorney that will represent the public for free, especially if there's a contract issue or a dispute over money. So when the contract says represent the buyer, this is what it specifically means. Additionally, in Georgia, and that's why this is in the GAR contract, not to confuse our public or confuse agents, but in Georgia, it is legally required that an attorney closing a transaction for real property disclose which party they represent. And again, it's in terms of these issues. So regardless, if you're binding on GAR, it has it in there. If you're binding on another contract form, the closing attorneys are going to have the buyers and sellers sign a document at closing that clearly states which party the closing attorney, quote unquote, represents if there's not a mortgage lender. Again, any issues, a party must sign a separate agreement to hire an attorney. And that has always been the case, but GAR has just now clarified that to help out our public and some agents to make sure they understand that. Now, I'm not going to go over these in depth. This is a section on earnest money. This is basically the holder of the earnest money. When the buyer and the seller, buyer and seller negotiate when okay, let me get rid of this now. Buyer and seller negotiate how many days from binding agreement date that the buyer is going to send the earnest money to the holder. But when we get to the corresponding paragraph down here, this is already pre-printed. So what gets negotiated is when the buyer sends it. What's already pre-printed is when the holder has to deposit it, as well as the form of the earnest money. So buyer and seller negotiate not only the form, but it clearly states here in this paragraph that the holder must approve of the form. So let's say buyer and seller agree that it's going to be a check for earnest money of $11,000. Well, the holder can say, I don't care what y'all agreed to. I don't accept that form, and you need to change it. Additionally, the holder may charge the buyer a banking fee if that is incurred by the holder. And pre-printed, the holder has 5 banking days to deposit the money once they receive it. The holder doesn't have to act on it until they've got verification it's cleared the buyer's bank. And if they never get it or it doesn't clear the bank, then the holder is responsible for notifying the buyer and the seller that the buyer is now in default. I have got no earnest money. In essence, you guys, the purchase and sale agreement is a receipt of by the holder for that money. If I'm named as the holder of the earnest money and I never get it, or I get it, but it bounces from the bank, you better believe I'm sending notice saying, this receipt is no good. I am not in possession of $5,000. Buyer, you are in default. Buyer then has 3 banking days to make good on the money. And if they don't, the seller may either terminate the contract or go through with closing without earnest money. You just need to make sure the lender knows and the closing attorney knows. And the buyer will just have to bring that much additional cash to close. This whole section on disbursement of earnest money, I'm not going to go over this in depth. Just want to point out a couple things. The 10-day letter and this section right here about W-9. This has come up several times in the past couple of years. And in essence, this is when, if there's no issues, this is when the buyer gets their earnest money back. If there are, additionally, in order for a holder to disperse earnest money, they must have written agreement by the buyer and the seller how they are to divvy up those funds. If there's issues and the buyer and the seller don't agree on who gets the earnest money, then the holder can do what we lovingly refer to as the 10-day letter. The 10-day letter basically, and that's all provided for in that paragraph, states that the holder gets to take off my client representation hat and now put on my neutral. I need to be a good steward of the money because my real estate license and my company's license, if I'm a broker and I'm holding the earnest money, are in jeopardy, are at risk. If I can't just give earnest money back to my client because they're my client. I can lose my license. So I have to be neutral third party, go through the contract, interpret the contract, and try to figure out what did the buyer and the seller agree to regarding termination rights. I make that interpretation. I send out where my intent to disperse the earnest money. And then before I actually send out the funds, I have to wait 10 days from the date of that notice to give the other party time to object if I've missed something in the contract. That's why it's called the 10-day letter. These funds are tied up during this time and may not be used for another contract. So you buyer's agents, if you have a buyer and they go under contract with seller number 1 and buyer terminates that contract within their due diligence period, but the seller won't sign the agreement to release the earnest money. Your buyer wants to go under contract with property number 2. Well, seller number 2 is going to want that earnest money. You cannot use the earnest money that the buyer has in for seller number 1 because it is tied up during this time frame. So your buyer is going to have to put in additional earnest money for that second contract. Eventually they'll get it as long as everything is, they did follow the proper procedures to terminate. But I've got more of those kinds of points written out for y'all at the end of the PowerPoint presentation. Now, additionally, as the holder of the earnest money, if the contract is too legally complicated, or if there's way too much earnest money, if the earnest money is like $15,000, $20,000, $40,000, I don't have to be responsible for that. I can interplead it into a court and let a judge decide. There are court costs for me to send this earnest money in what's called an interplead action, and I get to take those fees from the earnest money being held, so to cover my costs. Based on the county, the earnest money, the cost of an interpleader action can be a lot of money. So if the earnest money is less than $5,000, sometimes it might make sense for a buyer and a seller to negotiate the division of that earnest money rather than go to court and have a lawsuit. All right. These next section on, I'm going to get through this couple sections. Well, no, we've still got time. Okay. This next section, so all of that is all spelled out here. Interpleader action, hold harmless. The parties agree that they are not going to sue me for my decision as holder of the earnest money. Okay, this whole section on inspection and due diligence in 2023, a lot of this information was all smushed together in one big long paragraph or just a couple of paragraphs. So the GAR Forms Committee separated it out each topic to make it a little easier to understand. They added this new paragraph and they've expanded it. So you'll see this inspection and due diligence section is a lot longer than it has been on previous paragraphs. So I'm going to go over sort of what, not sort of, but I will cover what all of this states. So here we go. So in that, and again, this is just cut and paste from the contract I just showed you, all of the underlines and all of the separate paragraphs. But basically, as I mentioned earlier, the due diligence period, well, no, I'll get to that in a minute. The buyer in the contract has the right to inspect the neighborhood. To inspect the property and the neighborhood, even if the seller is selling it as is. And the buyer and buyer's representatives have rights to enter the property through closing because they're going to want to do a walkthrough. But you have to give notice to the seller. Just because you're under contract to buy a house does not give you 24/7 access. It's not your home. Somebody is still living there, or even if it's vacant, somebody still owns that property. So you still must give prior notice to the seller before entering the property. And buyer agrees to hold the seller and the broker, both brokers, harmless if throughout the course of their inspections by themselves, checking out the property, anybody they bring into the property, if they damage the property or break something, it is the buyer's responsibility to repair that property to the condition it was prior to inspecting. And let's say somebody gets injured in the property. They agree to not sue the seller nor to hold the seller and both brokers harmless. The buyer has the right per the EPA to inspect the property for lead-based paint hazards. And I'll get into that a little bit later. If the property or anything in the property was built, what's the year? What's the year that they stopped using lead-based paint? Type it in the chat. Oh, you guys are good. Yes, 1978. So just a quick note, though, if the house was built after 1978, but let's say there's an antique mantelpiece in the house that was built before 1978, or the seller redid something with shiplap from an old property or reclaimed barnwood. So if there's a chance that anything in the house or in an attached building or outside was painted before 1978, you need to use a lead-based paint disclosure, which is GAR Form F316, and you listing and you buyer's agents, the buyer is required by the EPA to have that disclosure prior to going under contract. And the buyer has a 10-day risk assessment, the legal right to assess the property for lead-based paint hazards for 10 days, unless in that disclosure, the buyer has waived that opportunity. But let's say either the house or something in the house was built or painted prior to 1978. And let's say buyer and seller negotiate for a 5-day due diligence period. But on the lead-based paint disclosure, the buyer does not waive their right for a risk assessment of lead-based paint. That is 10 days. So a buyer could have a 5-day due diligence period, but they could still, if they don't waive that right to check for lead-based paint hazards, they could still terminate that contract on day 8 from binding agreement date if it is found that there is lead-based paint and they're not willing to take that risk. So the lead-based paint risk assessment is 10 days provided for by the Federal Department Environmental Protection Agency, regardless of a due diligence period. But the right to waive that time frame is negotiated on this lead-based paint disclosure. If part of the home is built in 1912 and it was added to in 1993, Sue, what do you think you should do? Use the lead-based paint disclosure or not? Yes, I would use it. When in doubt, disclose, 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 disclose. All right. These next couple of slides I'm not going to cover verbally, but this is here for your reference, information about lead-based paint, where you can find additional information. Point of practice, you guys, I strongly suggest if you're working with sellers and the house or part of the house was built prior to 78, not only are you're required legally to have them complete a lead-based paint disclosure, but I also would give them that lead-based paint pamphlet. But you buyer's agents, I suggest you just include this in your buyer pre-listing, pre-buyer package. Get these pamphlets. GAR has them. Oops, I'm sorry. GAR has other consumer brochures. Include any and all disclosures for your buyers to make sure that they have information available to them. All right, and then here are just a couple of more resources for you regarding lead-based paint, federally and to Georgia specific organizations where you can get some information. All right, now the due diligence period. We're still in this paragraph B8. As I mentioned when we were going over it in paragraph A, it is a buyer's option to terminate with no penalty, meaning they keep their earnest money. They can terminate for any or no reason, but they must send that notice of termination before the due diligence period ends. And I'm going to get to this a little bit later when I get to the TNR agreement towards the end of class, but the termination of a contract and the release of earnest money are two completely separate contractual issues, even though they are addressed by the Georgia Association of Realtors Forms Committee on one document. Anybody can terminate, and termination only requires one signature. The release of the earnest money, however, requires both buyer and seller agree to the terms of the release. If they don't agree, then we go through that previous section on how the holder disperses the earnest money. Now, anybody can terminate, but you just said, but you're thinking to yourself, but Dana, didn't you say that the due diligence period is only the buyer's option to terminate? Yes, buyer's option to terminate with no penalty. So if a seller terminates a contract during the due diligence period, there's going to be a penalty because the seller has now just defaulted. So, and we'll get to what happens if the buyer or the seller defaults. So you can terminate it, but there are consequences to your termination. Did you terminate by something agreed to in the contract and there'll be no penalty? Or did you terminate and now default on the contract and there will be a penalty? So that's the difference. And earnest money is part of the penalty, not the entire penalty, but part of the penalty. Now, further on in that paragraph, even if a seller is selling it as is, again, that is just the seller initially communicating that they have absolutely no intention of doing any repairs or replacements. But by Georgia law, a seller is required to disclose latent material defects, which are defects of the property, material defects of the property that the seller or agent is aware of and that could not have been discovered by the buyer by reasonable inspection. Can be very difficult to prove. So for example, let's say you walk into a listing and there is a big old huge water stain on the drywall in the master bathroom. The seller is not required by Georgia law to disclose that. That is not a latent. You guys, latent is just a fancy word for hidden. That is not a hidden material defect. That is not required by the seller to be disclosed because the buyer can discover that by a reasonable inspection. I mean, you don't even need an inspection. You walk in and you see water stains. That's kind of what we like to call a clue that at some point there's been a leak in that master bathroom. That is not a latent or hidden material defect. Additionally, Georgia is what we call a caveat emptor state. The buyer is required, so to speak, to make themselves 100% satisfied with whatever goods or services they're buying before they go through with that sale. So there's all kinds of things, I've already mentioned this, that a buyer can do to help them make that decision. They can ask the seller to address concerns, but the buyer doesn't have to agree. The seller doesn't have to agree. If the seller is not going to do anything to the property, the buyer either is agreeing to buy the property as is, or must terminate before the end of that time frame. Due diligence period may only be extended by agreement. There is no unilateral extension of the due diligence period. So you buyer's agents, if the buyer has had the house inspected and is asking the seller to address some concerns, and you are coming to the end of your due diligence period, you have an amendment that you proposed to the seller, it's outstanding, you have not heard back from the seller, and you're coming to the end of your due diligence period. If you get to the end of that due diligence period and you have not gotten that amendment back signed by the seller, your buyer has just bought the property as is. So if it's a make it or break it issue, you buyers, you need to terminate the contract before the end of a due diligence period. In other words, an outstanding open-ended amendment to address concerns does not extend the due diligence time frame. Now, one quick question while we're here, point of practice. What happens if, let's say you're working with a buyer and you go and inspect a property and the utilities aren't on, or the contract, the house is in a homeowners association and you have not gotten the community association disclosure or something like that? Well, how do you protect the buyer's earnest money? Not only that, how do you protect them if the utilities aren't on? They're not going to go spend money with an inspector to try and inspect the property when the utilities aren't on and the inspector can't inspect it. But they don't necessarily want to terminate because they just put a contract on the house. How do you protect their earnest money in those kinds of situations? Well, please pull out your phone or print these and take a picture of this special stipulation, because yes, you would add this in a special stipulation because there's a lot of agents that get this wrong. So let's say, for example, the utilities aren't on. Well, and you know that when you're showing the property. Well, a lot of agents will write a special stip that says due diligence period to begin when buyer gets written notification that the seller has turned on utilities. Well, guess what, people? What if the seller never turns them on? You can't terminate your buyer because if you write it that way, due diligence period to begin when the seller does this, and the seller never does that. If you terminate the buyer's just gone in default. They're not in due diligence. They have no protection of that earnest money. So don't do that. The very bottom part of this slide, you guys need to write this down or take a picture of this. You buyer's agents, you always want due diligence period to begin when you go binding. Then you're going to extend it for a certain number of days after the seller does what they need to do. So in my example, you're a buyer's agent, showing the property, no utilities on, they go binding. You're going to, before you're binding, you're going to add a special stipulation, due diligence period to begin upon binding agreement date and to extend for 10 days or whatever number of days after buyer's receipt of written notice that seller has turned on all utilities and made them operational. That way, if you never hear from the seller, the buyer can terminate, get their earnest money back, and go on with another property. If the seller does turn on the utilities, but they turn them on 8-9 days after the binding agreement date, you still have 10 more days to pay for an inspection and get it all checked out. So again, due diligence, you always want that to begin upon binding agreement date and then extend for a certain number of days. Just quickly, if a buyer and a seller, if there are repairs that need to be taken, I highly, highly encourage you guys to negotiate that financially. Either the seller make a financial contribution as a buyer credit at closing, or the seller pays money to a third-party contractor, vendor at closing from their proceeds, or you come down in sale price, or you increase closing costs. It gets very, very difficult when a buyer and seller actually negotiate for a seller to complete the repairs. The contract states that they must be done in a good and workmanlike manner prior to closing. What happens if the seller doesn't do them? May a buyer terminate without defaulting? Not necessarily. May the buyer close and sue the seller? Not necessarily. There are no automatic termination rights for a buyer in a contract based on seller not completing repairs. And repair issues don't automatically survive closing, so the buyer may not have grounds for suing the seller. So what do you do? Again, this is information as a point of practice. I highly encourage you guys, if there are repair issues, this last special stip, at closing from seller's proceeds, seller to pay ABC vendor X amount of dollars. All right. Again, this is more information about other ways to take care of potential repair issues in a contract. As always, with any special stipulation you learn in any of my classes or any class, you definitely want to check those out with your own broker before using in a contract. But here are some special stipulations to address repair issues. This one is authored by closing attorney Amy Davis of Davis Associates, who is an amazing closing attorney in West Cobb. Does it survive if it's in writing? No, ma'am, it does not. And we will get to the what survives closing a little bit later on in the class. Here is another special stipulation to address repairs. And that's it for repairs. Okay, that's it for the inspection and due diligence. We are now in the section of the purchase and sale agreement. Lead-based paint, I've covered that in depth. We're on this section on brokerage relationships. I'm going to finish paragraph B. I'm going to cover brokerage relationships, and I'm going to cover this disclaimer and time limit, and then we'll take a break. So give me just a few more minutes to cover these next few sections, and then we'll take a break. And then we will go through paragraph C of the purchase and sale agreement and the financing exhibits. So here's where we are in the contract. We're under paragraph B10, brokerage relationships. And in 2023, the Georgia Association of Realtors Forms Committee did add a sentence referencing if a broker has both sides of a contract, but not in a dual agency relationship. So in other words, you're working with one side as a client and a customer. Let's say you have a listing agreement signed with the seller and you get a signed call, but the buyer does not sign buyer brokerage agreement. That would be having both sides. Or if you have a buyer signed to a buyer brokerage agreement and they go buyer for sale by owner, that would be both sides, but not dual agency. So let's knock out these next couple of things and then we'll take a break. All right, brokerage relationships. You must, again, per Georgia license law, which is why the GAR contract has it in here, you must disclose the agency relationship. And the client relationship in Georgia is contractually driven. What does that mean? That means the only way your public buyer or your public seller, it's true for landlords and tenants as well, the only way they are clients of your broker is if they sign a brokerage agreement that creates the client relationship. If they do not sign these agreements, then they are a customer. Regardless of if they are a past customer of yours, let's say let's say you're working with a buyer, and let's for example, let's say it's an investor, and you know everything about this buyer. You know what they're looking for. You know the finances they have. You know how much money they have in their bank account. You know all of that information, and you've helped them, you've worked with them on 5 contracts in the past. They find another house they're going to buy. If that public buyer does not sign a buyer brokerage agreement for the next transaction, regardless of the information you know about them, they are not your client. They are your customer. Now, you would disclose that as a material relationship, but the client relationship is contractually driven. Again, this is just a review of agency and some consumer brochures. So not only do you disclose the nature of the relationship between your broker and your public person, but then it goes on to describe what all of that means. And any commission earned by the broker is pursuant to whatever other agreement that public person has signed. There's no commission described that the brokers get paid in the purchase and sale agreement. All commissions that are earned are described in the brokerage agreements or the customer agreements. The instructions to closing attorney are signed between the brokers, agreed upon between the brokers, has nothing to do with the buyer and the seller. So further on in that paragraph, it goes on to say, well, let me ask you a question. Are broker agent signatures required? I've got the answer. The answer is no. So what does it mean when you as an agent sign a contract? Again, you guys don't just trust me blindly. I love that you do, but what have I said? Instructions. Let's see, what are you talking about, Dana? Why are you saying that? Here is where it is in the instructions. Under the brokerage paragraph, it says the brokers herein are signing this agreement. Here's why they are signing: to reflect their role in the transaction. Their role in the transaction is either that of the nature of the relationship, client or customer, their role in the transaction, and to consent to be holder of the earnest money if they're named as holder of the earnest money. This agreement and any amendment shall be enforceable even without the signature of any broker. So that's why I have this slide that says what it means, and they are not required. However, if there is a loan involved, there are some lenders that absolutely require the agent or broker signatures in order to sell the loan. Now, the next section in the brokerage section talks about the disclaimer. And sometimes this can be a bit tricky for an agent to go over with the public, because basically this says, I am a real estate agent. I am filling in the blanks in this legally prepared purchase and sale agreement for you. I am going over it with you. I have a fiduciary responsibility to look out for your interests with respect to the contract within the nature and limitations of my position as real estate agent. However, you public buyer, you public seller, you are buying a house. You are responsible for your own interests with respect to the property and the contract. That, in essence, is what this entire paragraph says. It says, buyer and seller, you have not relied upon any advice or representations of me. If you, you shall have, and me, agent and broker, I have no duty to inspect the property or advise you on the property, especially something that could have been revealed through a survey, appraisal, title search, termite letter, utility bill, blah, 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 financial planner, attorney, mortgage consultant, tax consultant. You are responsible for looking out for your own best interests before you go through with this transaction. If you have any questions, you should seek independent expert advice regarding those specific matters. It goes on to say that if I've written any special stipulations, you agree that they reflect your complete understanding and you adopt them as your own. This is also GAR's way of saying that any special stipulations written in the purchase and sale agreement, you can't come back on GAR. And if there is a question, and a broker / agent answers the question, they are doing so from information provided by the seller, not from my opinion. Yes, exactly. This can be tricky because you guys, I'm telling you, this is going to save you. This part in the contract saves you when there's an issue, but it can be tricky because the public is paying you a lot of commission, but there is a lot of work that you do. You earn your commission. You earn more than your commission in keeping these deals together. Again, nothing is an issue until it's an issue. And all of these next slides are just written out what I just discussed verbally. If the buyer asks you a question about the property, contract tip, I suggest you use GAR has a form 325 broker's information disclosure, where you write in the question, you fill in the answer, and you write in the source of the answer. And then the time limit of an offer. The time limit, a lot of agents mistakenly think that this is the time frame for the other side to just respond. That's not what it is at all. The time limit is only a time frame for the receiving party to accept the contract with no changes and send notice of acceptance. If they sign it and send notice of acceptance before the time limit with no changes, then you have a binding contract. If a party makes a counter offer, then it's not an accepted contract and the time limit does not matter. So this is not a time frame just to respond. And all right. The next section is starting with section C, and section C has to do with the notices. So I think now would be a good time for a break. So let me stop the recording. Let me stop the slideshow. All right, everybody, welcome back from the break. Again, this is the 2023 GAR Contract Dissection. A ton of information, and I appreciate your time and attention. Again, the reference where you can download all the handouts for your practice as a reference for you. Any contract questions, I do encourage you to run them past your own broker because your broker might have various policies and procedures, and you'll want to check those out before using them. But we're going to continue on. We're going to finish up with the actual purchase and sale agreement. We're going to go through the financing exhibits, and then there's just a couple of other documents I'm going to cover with you. I do encourage everybody to take additional contracts classes. We do have the class where we specifically just focus on the brokerage agreements and other amendments and exhibits and special stipulations. This class in and of itself probably needs to be divided either longer or divided into more classes. But I encourage you guys to just take additional classes. So I'm going to share my screen and we will get back started. Again, you guys are doing a great job. Thank you so much, Sue. Ask any questions in the chat. I know this is the proverbial drinking water from the fire hose. If nothing else, if you get nothing else from this class, I just want you to pay attention to, wow, that was something that Dana addressed in class. Like when you're in practice and it's something about earnest money release or something like that. There's something in the contract about that. I know Dana addressed it in class, so you don't have to remember everything I'm saying, but if you can just keep in your mind that this is something I address, and then you can go back to the resource and find more of the information, or again, check out my YouTube channel, Real Estate Made Crystal Clear. Call me, email me, contact your broker, contact an attorney. But just to have an awareness, so to speak, of what's out there. So let's continue on. All right, there's my YouTube channel, and let's go back. Let me show you where we are in the contract. We're still in the purchase and sale agreement, GAR F201. We're under paragraph C, other terms and conditions. And we're going to talk about notice, default, the rest of this information. But we're going to start with the notice section. And I'm going to go back to the PowerPoint. Thank you, guys. I appreciate the very kind words in the chat. I am very humbled. I love teaching, and I give glory to God that what I teach and what I think I am conveying is actually being conveyed. So I appreciate that feedback, and thank you so much. Just definitely honor God for the talents that He has chosen to give me. All right. Moving on, notice to the purchase and sale agreement. So the way we practice real estate here in Georgia, I don't know how they practice in other parts of the state or other states, but there's a lot of communication that happens via email between agents, between closing attorneys and agents, between lenders and agents, so forth and so on. There's a lot of communication that happens via email, via text message, so forth and so on. But again, we need to look at the instructions to protect our public buyer and our public seller. So the instructions give us the prescription or the exact way that we are to communicate regarding a contract or regarding something going on with a contract in order to protect our buyers and sellers. So what about this agent-to-agent communication? What about text messages? Do those count? Well, let's find out. Let's see what the instructions say. So the instructions talk about communication in terms of notice. And all in this paragraph, it says it must be in writing. So in writing, okay, text message, guess what, you guys? That's not in writing. You send texts through your phone. So that is not in writing. You cannot take a text message and transpose it to a piece of paper. That is not considered in writing by the contract. So it must be in writing. So you're thinking, okay, an email's in writing. Yes, but additionally, it says it must be legible and it must be signed by the party giving notice. You as the agent, the closing attorney, the lender, and the agents are not parties to the contract. The only parties to the contract are the buyers and the sellers. So it must be signed by the buyer or the seller in order. That's how communication occurs with respect to the obligations, consequences, and actions with respect to the contract. It can be in person. It can be delivered by courier overnight, U.S. mail, as long as it's certified or registered, or by email or fax. Nothing in here about phone calls or text messages. And not only that, but so when further information about communication by email, because that's mostly how we communicate, email is considered received when the sender can prove they sent it, even if the receiver never opens it. So let's say my due diligence period, the buyer's due diligence period expires tonight at 11:59 p.m. I can have the buyer send a termination notice and email it to the listing agent tonight at 11:58 p.m. Now, the listing agent could be asleep in bed, not on their computer, not working. They don't get it till tomorrow. Well, the buyer's due diligence period expired tonight. Even though the receiver doesn't open it until after that time frame deadline, it is considered received by the contract when I, as the sender, can prove I sent it at 11:59 p.m. Here's my email with the date and time with the attachment referenced. Text can be readily tracked and dated and proven, but all parties still have to accept and sign. Amanda, I appreciate that, but my information regarding the Georgia courts with respect to contracts for real property, they do not recognize text messages as written communication with respect to these contracts. Now, it might help you in an ethics hearing or in a GREC issue investigation. Nope. Putting it in, well, if you put the text in email, but again, it has to be signed by the buyer and the seller. So that would, so yes, I see what you're saying. Okay. Not only emailed to anybody, but it has to be emailed to the address, the email address that's on the signature page. But you guys, you need to be careful because a fax, if it's sent to a fax number on the signature page, that is also considered notice. So let me show you something. In the purchase and sale agreement, I'm going to skip to the end of the purchase and sale agreement. On the signature page, under the brokerage section, there is a place to put in a fax number. Some of your contracts or some of you will put in your broker's fax number. If notice is sent to that broker's fax number, but you never get it, it doesn't matter. They have still complied. So point of practice, do not put your broker's fax number there. Because if your broker, the staff at your brokerage isn't readily checking that and getting you that information, you might never get that document. And only put your fax number there if you're checking it. So I would suggest be very cautious. And if your forms auto-populate with your broker's fax number, you need to go in there and perhaps change it. And the email address here is the email for purposes of notice. All right, so not only that, so, oops, where are we? All right. And then just one more quick thing on notice, because this has come up actually this week in our brokerage, is if you are working with your public as a client, then you may accept notice and you might send notice, but it goes on to say that you cannot, it's not you, it has to be the signature of the buyer and the seller. And it says that in another section of the contract, paragraph C4J, no authority to bind. It says the broker and affiliated licensee, you cannot agree to anything regarding the buyers and the sellers with your signature alone, including contracts, amendments, exhibits, or terminations, or notices that are signed by the broker, but not the party. So they have to be signed by the party. We had an issue where it was a termination. It was a buyer terminating prior to the end of due diligence period, and the buyer's agent sent the termination notice on behalf of the buyer, but it was signed by the agent. The buyer had not signed it. And the buyer's agent said, no, we sent notice within the time frame. And it's like, no, it wasn't signed by the buyer. And the agent's argument was, well, the buyer is my client, therefore I can act on behalf of my client. Nope, 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 nope. It specifically says that you can send and receive notices, but it must be signed by the party. So unfortunately, that buyer's agent's misunderstanding of the contract, I guess that agent should have taken this class, just put that buyer in default, and that buyer either has to go through with the contract or has terminated outside of due diligence period. Now we're moving on to the default section. So what happens if one of the parties defaults? Well, if the buyer defaults, the only remedy, seller's sole remedy, the only remedy for the seller is to get the earnest money. If the seller defaults, the buyer either terminates the contract. Would they be able to, okay, hang on, I'm going back. Would they be able to if they had power of attorney for the agent? Yes. So that's a good question. If an agent has power of attorney for a public person, then that would have sufficed. You need to check with your broker. Many brokerages, Maximum One, for example, we do not allow our agents to hold power of attorney for our public clients or customers because it completely negates your E&O insurance. You have absolutely no protection. And you have huge liability because you, in essence, become the buyer or the seller for any legal issues moving forward. So I highly encourage you, well, you need to check with your broker's policies, but regardless of your broker's policy, unless it is a family member, I highly, highly discourage you from accepting power of attorney for your public buyer or seller. All right. Moving on, if the seller defaults, the buyer either terminates and they get their earnest money back, or they sue the seller for specific performance. That means it goes to court and a judge decides whether the seller has to go through with the contract or not. If they're going to sue for specific performance, their earnest money stays in the deal. Because if the judge awards that the seller has to go through with it, then earnest money is part of the contract. Y'all need to be really careful and check the county where the property is. My understanding is these lawsuits for specific performance are anywhere from 6 to 24 months before they're even being heard. That's a long time to tie up a property before an issue gets resolved by a judge. And however, y'all be careful when talking to your buyers about earnest money, because not only is their earnest money at risk if they default, the seller gets that. And your sellers, if your sellers are like, fine, I'll give the buyer back their earnest money, I'm going to sell it to somebody else for a higher price. Guess what? The brokers get to pursue commission they would have earned had the contract closed from any defaulting party. So, and in this crazy hyper market, we have had a lot of brokers legally pursuing commission from defaulting buyers and sellers. We've had a lot of sellers in this crazy market default. They went under contract with the one buyer, then they got a backup contract for a higher price. They terminated by default with buyer number one, accepted contract number two, and they are legally being pursued for commission to both brokers in the contract that they defaulted on. So it's not just earnest money at risk. There are commission, and if it goes to court or arbitration, guess what? The judge or arbitrator can say the loser has to pay the winner's legal fees and court costs. So there's potentially a lot of money at risk. All right, this part about the property, basically a couple of things I want to point out here. This says that at closing, the property is to be in substantially the same condition at closing as it was on the offer date, and clean and free of trash, debris, and items negotiated that are staying. So that means if the air conditioner was working when you went under contract, it needs to be working at time of close. It also goes on to say that if the property is substantially damaged by vandalism or an act of weather, then this tells you what you have to do. They can either stay in contract and wait till the property's restored, or they can terminate. So that goes through all of that information. Then the next section, I'm going to skip that for a minute, talks about assignment. Let me just quickly talk about this. There are a lot of investors in our market right now, and a lot of you agents are working with investors. So let me just very briefly talk about assignment. The GAR purchase and sale agreement in and of itself is not assignable. When a buyer signs it, the buyer has to go through with the contract. If the buyer, which is typically an investor, just wants to tie up the property or get a contract on the property, and then they want to sell their position in the contract to another buyer and make money for selling the contract, that's called an assignment. And just a couple of quick things. The seller must agree in writing. So you buyer's agents working with investors, you're going to want to use this special stipulation to get the seller's permission to assign the contract. And then there are a couple of other forms. There is an assignment of the purchase and sale agreement, which is signed between the investor or buyer number one and the assignee or buyer number two. And then there's a new form in 2023 where the buyer and the seller sign it. I'm not going to take the time in this class to cover that. I think I'm going to do a video on assignment, but I just wanted to let you know there are some new forms. Extension of deadlines, we already talked about that regarding the 8-day unilateral. There is a new provision in 2023 called the FERPTA affidavit, and that has to do with U.S. taxes and a foreign buyer. The closing attorney has to collect for U.S. taxes. And then there is a section on GAR forms, and it specifically states that no party is required to use the GAR forms. Additionally, regardless of what agents and brokers and buyers and sellers think they are agreeing to when they sign a GAR purchase and sale agreement, if there's an issue and it goes to court, a judge has full reign and can interpret the contract completely differently. If there's an issue or if earnest money gets interpleaded. And I just wanted to also write here that it doesn't matter if it's on a GAR form, an RE form, an attorney written form, a notebook paper, so forth and so on. You, by virtue of having a real estate license issued to you by the state of Georgia, you are beholden to license law. And license law states that you must present all written offers, and there's the reference to the license laws. We talked about that already. It goes on to say, this is a little bit interesting. I'm not going to spend a lot of time on it. I just want you to know this is in here. So I'm under this other provisions, which is a ton of information. There are all of these paragraphs here about notice of binding agreement date and if there's an objection to the binding agreement date. And I just want to bring to your attention that there is a lot of information in the GAR contract if there is confusion over that. Point of practice to you agents. You need to get, as soon as you go binding, you need to get on the same page, both brokers, both agents, with what is the actual binding agreement date. Why? Because the binding agreement date, for all intents and purposes, is day 0 for all the other contingency timeframes. So if you're looking at terminations and contingencies and protecting buyers' earnest money, you need to make sure that you are within the correct contractual time frame, and that time frame begins with the binding agreement date. So if you have any questions or issues over the binding agreement date, it is spelled out in the instructions how to resolve those issues. There's several paragraphs about that. Then another thing I just want to bring to your attention, there's another section about rules for interpreting the agreement. And basically that's the quote unquote hierarchy of what takes precedence over what. So you've got the pre-printed purchase and sale agreement, and then you have the fill in the blanks where you type in or handwrite in the information. Then you have exhibits, and then you have special stipulations. And they take precedence, or they're in force and effect in that order. So if you have a special stipulation that addresses an issue that's already pre-printed in the contract, your special stipulation supersedes or now is what they have to agree to. So for example, let's say you have a loan exhibit and there's an appraisal contingency in there, and it has all the information about the appraisal contingency, which we'll get to in just a moment. And then you write a special stipulation that says property must appraise for sale price. Well, that special stipulation just totally negated all the legalese from the appraisal contingency. Well, what happens if it doesn't? I have no idea, because you just now took the place, your special stipulation took the place of that pre-printed contract. Also, if a buyer is getting an FHA or a VA insured loan, the amendatory clause, which is just the fancy name for the appraisal contingency for a buyer getting an FHA or VA insured loan, takes precedence over anything in the contract, including any special stipulation. And basically, we'll get to that next. Basically, if a buyer is getting an FHA or VA insured loan and the property does not appraise for the contract sale price, the buyer may send notice of termination through day of closing, and they will get their earnest money back. And that takes precedence or controls even if buyer and seller have this appraisal gap stipulation where the buyer promises to pay money over a low appraisal. That is trickeration. You listing agents, don't be tricked. If the buyer's getting an FHA or VA loan, that appraisal gap stipulation may not as well be in there, because the buyer may terminate and they will get their earnest money back. And that is spelled out in this paragraph. And even if it's not, the FHA is a government agency that supersedes our contracts. Now, the survival, there was a question earlier about if it's in writing, does it survive? No, these are the things. There are very, very specific issues in the GAR contract that survive the contract. What does that even mean, survive the contract? That means that they are legally enforceable. The parties that said they were going to do whatever are responsible and legally required to do what they said they were going to do. And there would be legal or financial consequences if they don't, if what they said they were going to do fits into one of these things that survives the contract. There are 8 specific issues that survive the contract: commission, title, seller's written representation of the property and neighborhood. That's why many sellers won't complete a seller's property disclosure. Even if they won't complete a disclosure, they're still legally required to disclose hidden material defects, but it can be on any form. Buyer's indemnification obligations, if the property's been condemned, attorney's fees, and property taxes. But the last thing is it says any obligations the parties agree will survive. So there's a magic phrase for you agents to use in contracts regarding things like seller paying for a 1-year home warranty for a buyer, or repair issues. This came up in the discussion about repairs. After you say, let's say you write a special stipulation that says at closing, seller to provide a 1-year home warranty for the buyer from such and such company to be called in by buyer's broker, not to exceed X amount of dollars in cost. Then you're going to write, this provision shall survive closing. That means if you guys forgot to call it in and you go to closing, the seller would still be obligated to pay for that 1-year home warranty after closing. If you do not include that magic phrase and you close and you forgot to call it in, the seller is no longer legally obligated to pay for that 1-year home warranty for that buyer. Same thing with any repairs. Then the contract goes on to define banking days, binding agreement date, broker. Anytime it says broker, it also means you, the affiliated licensee. Business days, banking days, they all go through 11:59 p.m. And it's basically Monday through Friday, no weekends and no federal holidays. You guys, that's true for a banking day too. There is Saturday is not a banking day. The banks are not open on Saturday. They're open for consumer convenience, but there is no money changing hands on Saturday. So Saturday is not a banking day. And then I've already discussed material relationship. There is a warning for cyber fraud. You guys, be extreme. You need to let your public know to not trust anything they get via email or via text message regarding sending money, earnest money, security deposits, cash to close, payoffs, so forth and so on. The bad guys are hacking the emails and the text messages. Point of practice, because we're here in the end of February, you guys, for yourselves and your clients and customers, there are a lot of bad guys out there trying to defraud us and our public out of their tax returns that they're getting now. The IRS is not going to contact you by email or text. If the IRS is going to contact you, it is going to be by U.S. mail. They're not going to call you. They're not going to text you. They're not going to email you. Do not buy any of these methods that these bad guys are going to start using to try and get your tax refunds or your public's tax refunds. More tips on cyber fraud, limit to brokers' liability, and we talked about that. Signatures, we've talked about all of that. Woo! All right. Moving on. We finished the purchase and sale agreement. Yay! Okay, I got 30 minutes to knock out the rest. Counter offer, I'm not going to cover. I've got all the notes. Basically, the counter offer is the only form that needs to be signed. And it encompasses the original offer plus anything changed. And just want to bring that to your attention. I really want to get to the money. Let's really, I really want to cover these financing contingency exhibits. Conventional loan contingency exhibit. Again, per license law, if you are an agent and the contract for real property is subject to financing, it is a license law violation to leave any of this information blank. So make sure you fill it out. In 2023, GAR added this phrase under interest rate not greater than blank %. It also has in here, let me just show you quickly what the form looks like. That's the assignment, that's the assignment, that's the counter offer. Okay, this is let me make this a little bit bigger for you. Conventional loan contingency exhibit. This is where you fill in all the information. And this is the next stuff that we're going to use. For you agents that have been practicing for a while, something brand new for 2023. In all of the financing contingency exhibits, GAR separated out the time frames from the explanation of what the contingency is. So in the conventional, I'm in the conventional here. The time frame for the financing contingency period is now paragraph 3. And the time frame, if the property appraises less than sale price, to negotiate through that is paragraph 4. So it still has financing contingency that explains everything, but the time frame is now teased out into its own separate paragraph. So you experience agents, brand new, brand new for 2023. Okay, question about the counter offer. Does the counter offer need to state all other terms remain the same? No, that's assumed in the counter offer. It says here, original offer is hereby incorporated, only modified by what you put here. So you don't need to write that verbiage. It's already in there. Great question. All right. Loan. So when it talks about use of an approved mortgage lender, you would put in a lender. You are not required to identify a lender, and there's nothing that requires a buyer to use that lender. The list of the naming of a lender is only important if a buyer is going to terminate and protect their earnest money. If they're going to terminate under a financing contingency, they have to prove it with a loan denial letter. If you identify an approved mortgage lender, that loan denial letter must come from that person named. Again, length of financing contingency. Again, these timeframes are separated out in 2023. The financing, the appraisal contingency time frame. I'm going to cover this a little bit more in depth in just a second, but this gets really confused. So financing contingency period. The seller gives the buyer X number of days from the binding agreement date to convince a lender to lend them the money to buy the house. If not, the buyer has to send notice of termination before this negotiated time frame. The appraisal contingency is a little different. You still fill in an X number of days from the binding agreement date, but this is not a termination time frame. If the property appraises less than sale price, then the buyer has this number of days from binding agreement date not to terminate, but to propose an amendment to the seller to sell it to them for the lower sale price. And there's other time frames in there. But let's go back to the financing contingency. Again, denial can be for a different loan, but the loan denial letter must be the loan that was described up there. A buyer, this is another really, really important thing. If you go under contract with a conventional loan contingency exhibit, and the buyer's talking to their lender, and the lender says, you know what? I can find a better deal for you getting an FHA loan or a VA loan or USDA loan. That's all good and wonderful, except the buyer and seller agreed to the buyer seeking a conventional loan. So this is what it says here. You guys do not default your buyers. Do not harm your buyers. Do not lose them their earnest money. The buyer shall not have the right to apply for an FHA, VA, or USDA loan unless the parties agree to amend this agreement to add those contingency exhibits, and this conventional loan contingency shall no longer be part of this agreement. And not only that, so the buyer has to get the seller's permission before they change from a conventional loan to a government insured loan. And guess what? The seller doesn't have to agree to it. So be really, really careful when working with your buyers and the lender says, oh, I can get you a better deal. Now, again, if the buyer cannot convince the lender to lend them money, then the buyer must terminate the contract prior to that time frame by sending written signed notice of termination, and they have to prove it with a loan denial letter. Now, the loan denial letter, that negotiated time frame is when they send the termination. They have 7 days after they send the notice of termination to prove it with the loan denial letter. This goes on to say at the bottom here that just because a financing contingency ends doesn't mean the appraisal contingency ends. You guys, they are two completely separate things. Again, GAR now has them on one form. For those of you practicing for years and years, you will remember that GAR used to have the financing contingency as one form and the appraisal contingency as a completely separate form. They're now on one form, but they're two completely separate contingencies. One is an assessment of the buyer's ability to pay back the loan. The other is an assessment if the property would be satisfactory collateral should the lender have to sell it to recoup their process. How do you show proof? Great question. Here's the next. Let's go to the instructions. So here's the loan denial letter. So the proof is the loan denial letter. This is the proof. The proof is you must get a loan denial letter. It must be sent to the seller within 7 days after the notice of termination. Now, those 7 days can fall outside of the financing contingency time frame. It must be from one of the identified approved lenders if one was named. If no lender was identified, then it can be from any lender approved to do business in Georgia. This is all of this. Basically, my slides are all of this. But the loan denial letter is very, very specific. It may not be based solely on the following. In other words, the buyer's earnest money is not protected if the loan denial letter is based solely on buyer not having cash for their down payment or closing costs, buyer not having sold or leased current home if there's no exhibit, if the lender asks them for documents and they don't comply with the lender in a timely fashion, buyer's actions after binding. In other words, you're binding and the lender has pulled credit, and then you go under contract and then the buyer buys a boat or buys a car or loses their job, and now their debt to income ratio no longer meets that lender's requirements. So not only is the buyer going to lose their loan, they're going to terminate and they're going to lose their earnest money because they do not, that loan denial letter, that is not a reason that will protect their earnest money if that's the sole reason on the loan denial letter. Again, appraisal is a completely separate issue. And then look at this one. This one is a crazy one. So it's not just a letter, Sharon. It has to be a loan denial letter. And most institutional mortgage lenders have a specific form that they fill this out. But no, the termination notice. How do you prove these reasons? Yep, that can be a bit of a tricky issue. So lenders have also ethics committees that they have to, if you find that a lender is just outright lying, that's an issue with the mortgage. You would have to get in touch with the mortgage company's manager. But anyway, lender not having completed underwriting. And you're like, gosh, why is the buyer's earnest money at risk if the loan denial letter comes across because the lender didn't complete underwriting? Well, guess what? Who chose that lender? The buyer. So you buyer's agents, you need to get on your buyers, and they need to be really in very, very strong, strict, constant communication with these lenders. What number, I've got a question in the chat, what number of days should you put in the financing contingency and appraisal contingency? I'm not going to answer that because it depends on, oops, I have that twice. It depends on the market. In a fast-paced market, we have really, really short time frames. You need to check with the lender to see what the lender's time frames are. It depends on how much documentation that buyer has already shared with that lender? Is the loan already in underwriting before you go under contract? So those questions you need to get hammered out with the actual lender with whom the buyer is working. I will say that it will be much more attractive to a seller the shorter the timeframes are, but you need to check. A buyer should be in way deep communication with the lender before you ever write up an offer, a purchase and sale offer, to try and eliminate those questions. But great question. This next section, I'm not going to talk about. This goes on about this. You're past the financing contingency time frame, and the buyer did not terminate. Well, now the seller says, okay, now I want proof of your ability to close. Basically, I want a loan commitment letter from your lender. The time frames typically are crazy and end up, for a seller's right to terminate, usually what we're finding is these time frames come after your closing date anyway. And there's more important stuff I need to get to before this. I'll be more than happy to answer your questions about this at a later point in time. Maybe I'll do a video on this. I think I've done a video on the past, but it's in here. But just because you get a loan, you listing agents, just because you get a loan commitment letter from a lender does not mean that it's going to close. What is the difference between as is and no seller contingency? A contingency has nothing to do with as is. As is just means that a seller is initially communicating that they are not going to do any repairs or replacements. It has nothing to do with any contingencies. What if a buyer loses their job? Yep, if a buyer loses their job, that will more than likely be this section about a buyer's actions after binding. If they lose their job, not only are they, to add quote unquote salt to the wound, not only are they not going to get the loan, they're probably going to lose their earnest money too, if that's the sole reason that they're getting denied. So, yep, I hate it for the buyer. It's a tricky situation. All right, that's that information. Okay, appraisal contingency. Again, that time frame that you negotiate in paragraph 4 is just the time frame for a buyer. If the property appraises for less than sale price, the buyer, this is all spelled out here in this paragraph 13. The buyer has so many days not to terminate, but to send the seller an amendment asking the seller to sell at the lower appraised price, and they send them a copy of the appraisal. The buyer must give the seller the option to sell at the lower appraised price, or they agree to buy it for the higher price. In a conventional loan contingency, and you get a low appraisal, the buyer may not just terminate. You have to give the seller the opportunity to sell it for the lower sale price. And if the seller agrees, the buyer must go through with the deal. If the seller says, no, I'm not selling it to you for the lower sale price, then all these other time frames fall into play. And at that point, a buyer may terminate as long as you do so within these time frames, and they will protect their earnest money. All right. Whew. All right, let me talk about the FHA loan exhibit and the VA loan exhibit. The FHA, is this form right? I'm sorry, that was conventional. Here is FHA. Here is VA. FHA, everything is the same up until we get to the loan denial letter information. But for the fill in the blanks for timeframes, seller disclosure versus as is. Okay, so before I get to this, seller disclosure selling as is. By Georgia law, even if a seller is selling it as is, they are still legally required to disclose hidden material defects, but they can do it on any form. If a seller completes the GAR seller's disclosure form, then they're still disclosing not only hidden material defects, but all of their knowledge about the house. All of that information survives closing. So a seller may still fill out a seller's property disclosure form and still sell it as is. Those are not mutually exclusive things. Okay, moving along back to the FHA. You only see the time frame for the financing to terminate and protect buyer's earnest money on the financing contingency. There's no time frame for an appraisal contingency. Why is that? The amendatory clause is the fancy paragraph in an FHA and a VA insured loan that in essence that says the property must appraise and what happens if it does not appraise for the contract sale price. A buyer's earnest money is protected on a low appraisal through day of closing. There is no separate time frame for a buyer getting an FHA or a VA insured loan to terminate on a low appraisal. That it goes through day of closing and their earnest money will be protected. That is why there is no separate time frame on the FHA loan or on the VA contingency. Again, just the time frame for the financing, not the appraisal. So there's a couple of other different things on an FHA and VA insured loan, but here, let me just go over the slide. Same as conventional up to the loan denial information. Again, as I just said, no time frame for the appraisal contingency because it goes through day of closing. Loan denial information is the same, except for low appraisal is covered in the amendatory clause. I just said that. Now, in the FHA exhibit, you have to fill in the blank with the sale price. Again, as I said at the beginning of class, if there's a fill in the blank and it's preceded by a $sign, that calls for numbers, not words. Remember, you buyer's agents, if you write an offer on behalf of a buyer and they're getting an FHA insured loan, and let's say your offer is $350,000, and say your FHA loan exhibit in this paragraph 12 is going to say $350. If you get a counter offer from the seller with a new sale price of $400,000, you need to go back and change this to reflect the new counter offer, if that's what the buyer is going to agree to. It's what I said there. If the buyer is getting an FHA or a VA insured loan, and the appraisal comes in low, the buyer may terminate. They can't just not show up, but they may send notice of termination prior to 11:59 p.m. day of closing, and they will get their earnest money back regardless of any special stipulation in the contract. Now, a buyer also has the right to ask the seller to sell it to them for the lower appraised price, but it's not required. But if the seller does agree to sell it for the lower appraised price, then the buyer is obligated to go through with the deal. Now, additionally, in an FHA insured loan or a VA insured loan, there are repair issues that are negotiated if not just general repair issues, but if the FHA or VA appraiser mandates repairs. And so you negotiate, buyer or seller is going to pay as long as they don't exceed this. And what happens if you do exceed this? It's all written out what happens if the FHA or VA appraiser mandated repairs are more than what was negotiated when they went under contract. Additionally, in an FHA and a VA insured loan, there are other fees that the seller is required to pay, and those include tax service fees, lender required inspection of septic and well, lender required home warranty. so forth and so on. The property may be required by the FHA to be connected to sewer, and that dollar amount gets negotiated. And then there's a section just on the FHA and VA loan exhibit where you have to disclose if there is a relationship between the buyer and the seller. VA loan contingency exhibit, same as conventional and FHA up through the amendatory clause. The concept is the same. The only difference is there's not a fill in the blank for the sale price. It just says reasonable value as established by the VA. The only different thing in a buyer getting a VA insured loan is there is a required termite letter. And it used to be that the seller had to pay for that. Now, for you experienced agents, in 2023, GAR has changed it. So don't miss this right here. The initial termite clearance letter is paid for by the buyer or the seller. That's brand new in 2023. And then all the rest of this is the same regarding the termite clearance letter. And if there was previous infestation, the seller has to correct any damage, and the seller is responsible for getting a second termite clearance letter after anything has been repaired. Quick issue for you agents working with buyers getting a property in a condo or townhouse community. If they're getting an FHA or VA insured loan, please, 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 please protect your buyer's earnest money by including this special stipulation. Because a lot of condos, it's a condo by condo decision whether or not they fill out the paperwork to be approved for FHA or VA insured loans. If they're not, you don't want to find this out after due diligence period later on and have a lender find that out and lose your buyer's earnest money. So please, condo, townhouse, FHA, VA loan, use this special step. Okay. Now let's talk about this form. If there is no financing, what if a buyer is paying cash? This form has been pretty drastically reworked by GAR in 2023. You guys hang in there. We're doing great. Almost done. It used to be called the cash exhibit. It is now just called the no financing contingency exhibit. They've changed. This is a brand new paragraph that says method of purchase. Is the buyer actually using cash, or is the buyer getting a loan, but they're just choosing to potentially risk their earnest money by saying, I know I'm going to get the loan. If I get turned down for the loan, that's fine. I'll risk my earnest money. I'm not making the entire purchase and sale agreement contingent upon me getting the loan because I know I'm going to get it. Or you agents working with investors, if they're going for a hard money loan, not from an institutional mortgage, you would use this exhibit and fill out this finance portion. Now, what got changed from 2023, not only is it a difference between all cash and no financing, but if either of these options, what also got changed is there is no longer the option to extend the contract for 8 days unilaterally. So the only way, if there's no financing or it's not contingent upon financing or it's all cash, you can still use the 8-day unilateral extension only if it is a closing attorney issue based on title or scheduling, not if the closing attorney is delayed due to a mortgage issue. So that we completely take any mortgage lender out of it, even if they're getting finance. That is the biggest change for 2023 on this no financing contingency exhibit, which used to be called the cash exhibit. Now, if a buyer is getting all cash, they do have to provide verification of funds within so many days from the financing contingency. And then buyer and seller can negotiate an appraisal contingency if they want to, but it's not required. All right. Community association disclosure. I'm not going to go over this. In essence, a seller is required if the property is in a, if there's an HOA or management company that governs that community. You listing agents, you need to include a community association disclosure exhibit, and you need to have the sellers fill in all the dollar amounts. Any fees not filled in or are filled in low, at closing, the seller has to pay those fees, even if they are buyer fees. The reason is not designed to punish a seller, but the reason is a lot of these management companies will not talk to anybody other than the seller on record. And all of that is spelled out in the community association disclosure form. And just a couple of things on the closing attorney as holder of earnest money exhibit. Let me see what else I've got to cover. That. Okay. Couple of important things. Let me just show you this in the forms. Okay, this is the community association disclosure. I've got everything outlined there, including who pays what and the seller having to pay anything left zeros or low. This is the closing attorney acting as holder of earnest money exhibit. This is what a buyer and a seller sign and you use in the contract. And the closing attorney has to sign this next form, F511, within 3 days of getting the contract. This is only signed by the closing attorney, and it comes after a binding agreement. So this is not part of the contract. This is only signed by the closing attorney, and it comes after the contract. This is the exhibit that is part of the purchase and sale agreement, and this is initialed by the buyer and the seller. But a couple of things. You guys, if the buyer and seller choose to have the closing attorney as the holder of the earnest money, and it is an all cash transaction, and the contract doesn't close, and buyer and seller do not agree on who gets the earnest money, it must go to court. The closing attorney may not do that 10-day interpretation letter like I talked about earlier. That is only for brokers in an all-cash transaction, or brokers or closing attorneys if there's a mortgage lender involved. All cash, be very, very leery of the closing attorney holding the earnest money, because if there's a dispute, it has to go to court. So you've just put your buyer and seller in a lawsuit, and there are costs associated with that. That is key that I needed to point out to you guys in that. Backup contingency exhibit. Just a couple of things I want to point out that got changed in 2023. It used to be there was only one primary agreement and one backup. Now there is a place where there can be more than one binding backup agreement, and you reference what place this is in. And if you have a primary contract and backup number one, and then the seller goes under contract with backup number two, there is this brand new form, addendum to backup agreement, that you use after the main contract. So this would be for a buyer. You name the primary buyer, you name the second, third, fourth, and fifth. And the seller, if these contracts terminate, you have to go in order. And you reference these contracts by binding agreement date, buyer's last name, and broker. We've talked about that. T&R, just a quick thing about a termination and release. As I mentioned, Only one signature required for termination. Both are required for the disbursement of the earnest money. And all of this information is, again, spelled out in lots and lots of verbiage in these slides. If you terminate and the parties decide to go back under contract, there is a form that was new last year called Agreement to Reinstate the Contract. So I just want to bring that to your attention. I have a lot more information for you regarding earnest money and termination. Woo! Right on time. We made it. We made it. If you are leaving, again, please, one last time, type in the chat your name, license number, email address, and phone number. I will stay on to answer some questions. There is some more information for you. Credits will be recorded within 3 to 5 business days. If you do want to ask a question, there's a lot of information going very quickly in the chat. You are more than welcome to unmute yourself, but please mute yourself back so that everybody can hear the question. I thank you guys so much. Woo, so much information. I thank you for your time and attention, and I look forward to seeing everybody on another class, but I will stay on for a little bit to answer any questions. That was a lot of information. My pleasure. Thank you, guys.
Hi, Dana. I have a question.
Okay.
With regard to section C4H regarding the GAR forms, you say no party is required to use the GAR forms. Mm-hmm. Would that address like when you put in on like FMLS or GAMLS? So some people say that you have to use the GAR form, or does that address that at all?
Yes, GAR. So there's a little bit of controversy or issue when a buyer chooses to use the RE forms, for example, rather than a GAR form. And some agents misunderstand their broker when their broker says, we only accept GAR forms. Well, a broker cannot dictate what a public person chooses to accept, number one. Number two, by license law, which is what I put all of those references to license law in there, you are required by license law to present all offers. If it's on a GAR form, if it's on an RE form, if it's on an attorney written form, if it's on a HUD contract, if it's on a builder new construction contract, if it's on a notebook paper, you are required. So a broker may have a policy, for example, about you as an agent initiating an offer on a GAR form, but you can't dictate what the public writes an offer on, and you have to present all offers. So if you are in a situation where a co-op agent is saying that, I encourage you to get with your broker and get your broker to get with their broker, and I pretty much guarantee that will be resolved.
Awesome. Thank you.
My pleasure. Because also a broker that says we only accept GAR forms, that means none of their clients can buy new construction. The majority of new construction contracts are on Atlanta builder forms, not GAR forms. HUD House, Fannie Mae, Freddie Mac, attorney, so forth and so on. I had another question about proof of funds in an all-cash transaction. Does it need to be notarized? Nope. My pleasure.
Hey, Dana.
Yes.
I want to have a follow-up question with the GAR form. So I heard that the GAR form is more, protect the buyer or seller rather than the RE form, because it's more like strict or something like that. So usually the broker would prefer the GAR form, except for those like new construction or those things. So, for example, the sellers, the listing agent still presented RE form, the contract to the seller, but can the seller say, I'm willing to negotiate with this, but you guys need to present the offer with a GAR form? Like, But for example, the main reason maybe the other party using the RE form is because they don't want to pay for the GAR form to use it. So the question is, and then the buyer's agent does not have access to the GAR form, and can they use the listing agent's GAR form to present the offer?
Yes, the listing agent would have to share if you are not an authorized user of the GAR form. Yeah, the present. Okay, hang on one second. The presentation, I don't share the PowerPoint, but I share the PDF of the slides. And again, you guys, that's where I've showed you several times where you can get them. Shoot. It is on eagentweb.com, and all the handouts, including the slides, are on eagentweb.com. You click under training videos and scroll down. So if you are not, the way you are an authorized user of GAR, if you are a realtor, then you have access to the forms at no additional cost. Or you can pay GAR to be an authorized user for the year. Or if you are a co-op agent and your signature is on the signature page, the other agent, if they are an authorized user, they may share the GAR forms with you, but they have to share with you the blank forms. If they choose not to share them with you, then you just have to write it up on an RE form or whatever forms are available to you. Now, also, you guys, you're not attorneys. It is the unauthorized practice of law for you to advise a client on what forms to use or not use. Now, you can explain the forms, and that's why you take these contracts classes, but it is up to a client on paper. You guys, you have to understand what I'm saying on paper versus in reality. But if you explain the RE forms versus the GAR forms, and a client or customer says, I don't care what the broker says, I like the terms of the RE forms, I like the terms of this contract, I had my attorney write a contract, I want it written up on that. You have to write it up, and if you receive that, you have to present it. It doesn't matter what your broker's policies are. There can't be a policy on accepting any form. I mean, that's just, you have to present all written offers, period, regardless. It can be on a notebook paper, it can be on a sticky note, it can be on a huge long text message. But yes, you would have to get the GAR forms from your co-op agent. When putting financing and appraisal contingency dates, do you need to make sure the dates go in line with the original binding date? The contingency timeframe dates are just days from the binding agreement. It's just like 10, 14, 21, 28. So you won't know when the end of those timeframes are until you have a binding agreement date. So let's say, okay, so today, for example, is February 28th. And let's say I had a 21-day financing contingency. Well, so I write the offer today. And the seller signs it and sends it back to me, signed. So our binding agreement date is today, February 28th. February 28th is day 0. So then March 1st, 1, 2, 3, 4, 5, 21. So the contingency time frame, Mariana, would go through 11:59 p.m. on March 21st. But let's say, for example, I'm working with the buyer. I write the offer today, February 28th. We negotiate back and forth, back and forth, back and forth. We don't actually have a binding agreement date until March 2nd. March 2nd now becomes the binding agreement date. But the time frame for, let's say, the financing contingency was 21 days. Well, now March 2nd is day 0. So now we start counting. The March 3rd is day 1. March 4th is day 2. So we would be 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. So now that contingency time frame would expire at 11:59 p.m. on March 23rd. So the contingency timeframes are number of days from binding agreement date and binding agreement date is day 0. Another question, may I explain sub-agency? We do not practice that in Metro Georgia anymore. Basically, sub-agency was, you would work with the buyer, but you would not sign a buyer brokerage with the buyer. You were actually, the seller was the client of both the listing broker and the buyer's broker. You had a client fiduciary responsibility to the seller, even if you're working with the buyer under sub-agency. Again, they may practice that in other parts of the state or other states in the country, but we don't practice sub-agency here in Metro Georgia anymore. Not since the early 2000s and buyer brokerage came.
Question.
Mm-hmm.
If the sales and purchase agreement has a price, sell price is higher than the FHA contingency, sales price is lower, which is enforceable if the appraisal came lower? If there's a two price on the contract, one is higher on the sales price and FHA is lower on the contingency agreement, which is enforceable?
Which do you think?
I think is it the FHA one?
Yes, exactly. That's why I said, if you are working with a buyer and you're writing and they're getting an FHA insured loan, and on, let's say on the FHA loan contingency, you put, let's say the buyer's offer was $300,000, and on the FHA loan contingency exhibit under the amendatory clause paragraph, you fill in must appraise for $300,000. Then let's say the seller writes a counter offer, and the seller writes a counter offer, says, no, I'm not going to sell it to you for $300,000. I'm going to sell it to you for $350,000. You're the buyer's agent now. So you have a counter offer from the seller, and the only thing that was changed was the sale price. That only changes the contract sale price. That does not change that fill in the blank dollar amount on the amendatory clause on the FHA amendatory clause. So now you're under contract for $400,000, but the FHA amendatory clause says it must appraise for $350,000. So now you have the FHA appraiser goes out there. You're under contract for $400,000. The FHA amendatory clause is $350,000. Property appraises for $350,000. May a seller terminate under that appraisal clause, amendatory clause, and get their earnest money back? No. So they met the terms of the amendatory clause in the per FHA guidelines, but they're under contract with the seller for $400,000. So guess what, you buyer's agents? You need to bring $50,000. The buyer has to bring an additional $50,000 to closing, or if they terminate, they'll lose their earnest money. That's why it is extremely important, if you're working with an FHA insured buyer and you write an initial offer and you get a different sale price as a counter offer from the seller that's higher, don't accept it. You need to do another counter offer that says all parties agree that paragraph 12 of FHA loan contingency exhibit, amendatory clause of FHA loan contingency exhibit shall also read $400,000. That answer your question?
Yes, thank you.
Yes, you're welcome. Okay, question in the chat. Can GAR forms commingle with RE forms? It depends. It can be tricky, Sue, but it really depends. So for example, let's say the buyer and seller go binding on the RE forms purchase and sale agreement. Well, this wasn't a class on that, but there's no provision for an 8-day unilateral extension. So they're binding under that, no 8-day unilateral extension. And you get to closing and there's some issues with the loan or whatever. You cannot now use the GAR 8-day unilateral extension notice, because that GAR form, that wasn't something provided for that the buyer and seller agreed to in the purchase and sale agreement. So no, in that situation, no. But let's say that you're binding under the GAR purchase and sale agreement, and you have to do an amendment to address concerns, or an amendment to change the closing date or whatever. You can use an RE form amendment for that. It doesn't matter. There's nothing that says there's nothing that says the buyer and seller have to use any specific forms. Let's say parties are binding under the GAR purchase and sale agreement, and then the seller uses the RE form, seller's property disclosure form. They can do that too. You just have to be sure that the terms of any additional forms, exhibits, or amendments don't go against something that the parties have agreed to. And you need to make sure your buyers and sellers understand the forms, and it's their choice what forms they choose to use. That answer? Okay. Is this why most sellers want conventional, not FHA? A couple of reasons. FHA, there's a lot of FHA more mandated repair issues where they're not as prevalent in conventional issues, number one. Number two, there are seller required costs in the government insured loan. There's tax service fees. In a VA loan, there's a termite, all those termite issues. And an appraisal, an FHA or VA insured appraisal, that value sticks with the property on an FHA or VA insured loan where they don't on a conventional. So that's the reason for that. Any other questions, anybody?
Dana, I have another question.
Okay.
So you mentioned that for all cash offer, I mean, the non-financing contingency form, if it is used, and if there's a dispute about the earnest money, and you choose the closing attorney as your earnest money holder, and they have to go to the court to resolve it. So in that case, if you have one of the brokerage firm to hold the earnest money, then so my question is, like, for example, if it's obvious, like one party defaults, say the buyer didn't terminate before the due diligence period of time, and the seller does not default, will that causing any dispute, like, or as a broker, if it seems very clear to you, then you always just distribute, disperse the fund, go back to the, not go back, for this case, it's going to be, the seller is going to keep the earnest money. Like, I'm just kind of a little bit confused about it.
So license law and the contract says that you must have buyer and seller's written consent agreeing to the disbursement of the earnest money. If not, then there's other things that fall into play to figure out how to disperse it. If it's an all cash transaction and the broker is holding the earnest money, the broker can do the 10-day letter and disperse the earnest money based on their interpretation of the contract. If it is a loan, the broker can do the 10-day letter and interpret the contract. Or the broker could also send it to court if it's complicated or a lot of money. Even if it's obvious, if it's an all cash transaction or no financing and the closing attorney is holding the earnest money, the closing attorney must send it to court if you don't get buyer and seller signatures on the release. So for example, like you're saying, let's say let's say there was a 10-day due diligence period and a buyer sends notice of termination on day 5 to the seller, and asks for the earnest money back to the buyer. The seller, for whatever reason, won't sign the agreement to release the earnest money back to the buyer. Either they can't find them or the seller's upset and just won't sign it. Even when it's that obvious, if the closing attorney is holding the earnest money and it's all cash, guess what? You are now going to court. It is now a lawsuit, and the closing attorney has no option but to send it to court And there are court costs involved, and the closing attorney gets to take those fees and costs out of the earnest money that gets awarded, and the loser will have to pay the winner's attorney's fees in court. That's why if it's an all-cash transaction, y'all need to point that out to your buyers and sellers and think really long and hard before having a closing attorney hold the earnest money in an all-cash transaction.
Okay.
Even if it's obvious, you still are required to get buyer and seller's written agreement on the disbursement of the earnest money. It's a big deal. All right, anybody else?
If it is the broker holding the money and one party does not sign, broker can interpret it and then just disperse the fund, right? According to what you said.
The broker can, regardless if it's a loan involved or cash, if the broker's holding the earnest money, the broker can do the 10-day contract interpretation, or the broker can interplead it into court also. There have been situations where they've been extremely complicated, or it's a lot of earnest money, $20,000, $30,000 earnest money. Guess what? I'm probably sending it to, unless it's that obvious, I'm probably going to interplead it because I'm going to let a judge be responsible for that much money. But a broker also, guess what? I've got a real estate license and my firm has a real estate license. My license is in jeopardy. A closing attorney, they don't hold a real estate license. So they can't do anything illegal with the money, but they're not in jeopardy of losing their license or their license to practice law being harmed. All right, anybody else?
I have a question with regard to the special stipulations for due diligence. There is a blank there, and I'm not sure what goes there. It says to begin upon binding agreement date and extend 10 days after buyers receipt a written notice of, and that part was blank.
It depends on what the issue is. So, for example, my example, Deborah, was let's say the utilities aren't on. So it would be buyer's due diligence period to begin upon binding agreement date and extend for 10 days after buyer's receipt of written notification that all utilities are on and operational.
Oh, okay.
If the issue is, hey, we have no idea how much the HOA fees are, we really need the seller to fill out that community association disclosure. Then it would be buyer's due diligence period to begin upon binding agreement date and extend for 10 days or whatever after buyer's receipt of written completion of community association disclosure form. So it just depends. That fill in the blank is depending on what it is you need the seller to do.
Gotcha. Thank you.
You're welcome. Anybody else? All right, everybody. Woo! Thank you guys so much.
Yes. Thank you. This was awesome. I've taken hundreds and hundreds of CE classes. I've never heard anyone explain about the cash to the closing attorney for earnest money. Never heard that before.
Oh, well, my pleasure. My pleasure. Please check out my YouTube channel. Like I said, I've got lots of long-winded explanations about a lot of these contract issues. So I thank you guys so much. Have a great day. Go be a blessing with your real estate license. And I look forward to seeing you guys in another class. Thanks, everybody.
Thank you. Bye.
Bye.